Okay, looked like it worked that time. So those of you who are watching on social media should see us live now. And let me be the first to welcome you. It's great to see everybody here. And again, apologies for starting a few minutes late, but hey, we're here. So let's jump right in. So what I'm going to do is I'm just going to share a few thoughts before I hand the presentation over to our presenter, Julian, today. Of course, I want to thank you for joining us and welcome. My name is David Greenberg. I am the founder and managing director of the Freedom Studio, as I'm sure you guys all know. But for folks who are joining us on social media, we are broadcasting live on 4 different platforms today. We are broadcasting on YouTube, Rumble, Facebook, and LinkedIn. As always, since you guys joined us and are joining us in the Zoom meeting, I encourage you to keep your cameras on. Check your mic. You won't be able to unmute yet, but we will have time for Q&A as we go through the meeting. We'll talk more about how that works when we get to that part. As a reminder, this is part 2 of a 2-part workshop series. Ideally, you would have either attended or watched part 1, which we did re-upload. If you haven't, that's okay. You'll still be able to get a lot of value from the interaction today. It's just, it is cumulative knowledge, and having gone through part 1 will be helpful. If you haven't already, you can just catch the replay and re-upload a part 1 on our YouTube or Rumble channels. And it may also be available on some of the other social media platforms. Folks, there is nothing new under the sun. There is nothing new under the sun. Knowledge is eternal and timeless. And a lot of the concepts you'll be learning today are not, this is nothing new. This is not something that we came up with, right? This is really old stuff. It's just we're bringing it to light, and it's just not widely taught. Jim Rohn, who was a well-known business coach and mentor, famously said, "All good will be attacked, everything of value must be defended." Very profound statement, points to the deeper truth that if something is of value, we need to protect it. We need to protect it and defend it. And that's a lot of what we're going to be focusing on today in today's workshop. Also, keep in mind that just because you haven't come across a lot of this knowledge doesn't mean it's been hidden, truly hidden. We call it hidden in plain sight. It's always been around. Most, if not all of this is publicly available, and it's not taught, right? So part of our goal here is to bring it to the forefront for those of you who are ready to receive it. As it is said, when the student is ready, the teaching will appear. So I want to invite you guys to be highly teachable, pay attention, obviously, ask good questions, and otherwise enjoy this experience. Enjoy the education, the learning that you're going to get today. This is obviously an introductory workshop. So you're not going to learn everything in one workshop, but we're going to try to expose you to some of the most important principles and concepts, which will kind of essentially open the door to what's next for you on your education journey. And there will be on offer opportunities for you to go deeper into that study. Having said that, I'm going to turn the presentation over to Julian Swan of Standing on the Rock. As you guys know, we have partnered strategically with their private ministry for more than a year now, and it's my pleasure to have Julian present what they put together as far as the equity trust system, where you're going to learn how to employ maximum asset protection. So thank you, Julian. I'll hand it right over to you.
Thank you, David. Thank you for this opportunity to speak to all your members today. And very well put. There is nothing new under the sun. Some of this is 700 years old, in fact. It's hard to find it all in one place, though. In fact, impossible. So before we begin, I have a little presentation for you all, but I'd like to start us out in prayer. Thank you so much, Almighty Lord, Father God, that you have given us a way to reclaim what the locusts have eaten. Lord, there's so many people here today and that come to us on a weekly basis who have stories of the locusts and the cankerworm and all the devouring pests sent upon their families by Babylon that have eaten up finances, that have eaten up opportunities. And we know, Lord, that you have preserved a way for us to protect our assets, our opportunities, our futures, our finances, a way to preserve the kingdom resources that you have placed before us and given us the responsibility over. So, Lord, help us all learn today how to be good stewards of the finances that you have equipped our families with. Help us to never again allow dissipation and depletion of the opportunities and the resources that you have intended for our destinies. For you made us all, Lord, before we were even in our mother's wombs, you made us all for a specific purpose, each and every one of us. There are things that you want to do in the world that you can only do through each individual person here today. And we thank you for choosing to share that authority with us when you didn't have to. So help us to walk it out. Help us to defend our mission. Help us to be like Nehemiah with a sword in one hand and a hammer in the other, defending as we build. And help me to impart the words and the teachings that will help us to do that. Guide us, use us, and teach us. In Jesus' name, we thank you. Amen. All right. So we're going to go through a little slideshow today, and we're going to talk about um, the equity trust system. Of course, we're gonna teach on some things as well, and you're going to find the keys to truly unlock the most sure and safest path to achieving your destiny. So my wife Margaret and I have been studying trust for several years now. Originally, our students began requesting us to teach a separate class on trusts and other entities because there's just so little out there that's done right. We were soon invited to sit on the board of a company procuring equity-minded trustees. We learned a lot through that process. We took several trust classes that were out there, and we paid for several trusts that just wound up sitting on the shelf collecting dust because no one was teaching how to actually operate in them day to day. They were just teaching basic theory. And then we put together our own class. It's a very deep and wide subject, especially because there are significant differences for our Canadian and Australian and New Zealand and British students. I've reviewed what is on offer out there, and I can confidently say that we have the most robust, comprehensive, non-statutory trust class in the entire world. It's also the only trust class I know of that teaches how to write trusts in the original trust jurisdiction of equity, rather than common law or, of course, statutory commercial law. It's our goal to hold nothing back from our students. We don't want to be gurus. We empower our students to do it all themselves. Of course, we are always available for support and ongoing coaching. So we guide you through how to create degrees of separation, layering multiple entities together for maximum liability protection. When it says there on the slide that it's a mobile fortress, it means we give you the versatility to freely move assets as needed, change jurisdictions if needed, without incurring excessive fees. Most trusts out there are only using one trust and not in any really effective manner. They give you one sitting duck trust and they don't even tell you how to operate it effectively. They don't tell you all the powers you have to move the assets if the trust assets come under fire, or how to change jurisdictions or need if you need to. Um, and if they do tell you how to move something, you wind up paying massive property transfer taxes and all sorts of other things. So there's definitely a better way. So I want to take a few minutes to discuss the majority of asset protection material that's out there. 9 out of 10 people who come to us thinking that they've already got trust figured out show us their trust contracts, and they inevitably, most of these people have been made the trustee of their own stuff. It's extremely common to see that in the patriot world. It is fundamentally flawed. and we'll get to why in just a second. Another thing we see a lot of is the combination ministry slash trust. The 508c1a ministry is very popular in the United States. It's also very normal to see people with common law trusts, what people term natural trusts or natural law trusts. People have divine biblical trusts. We've seen just about every kind of patriot trust out there. All these tend to be written in commercial law or common law. We've never seen anybody write a trust purely in equity, even though equity is the original jurisdiction for trusts. I'm really not sure why people want to dilute their power by writing outside of equity, but we'll talk about all this on the next slide and how we strive for a higher standard of privacy. The thing we see most commonly in other people's trusts is that they are made the trustee of their own stuff. And while this will allow you to do business for a little while out in the world, you can convey property and assets and whatnot. I mean, it's not like banks really care too much who the trustee is. Eventually, if it ever gets scrutinized, it will be scoffed at by a court or a tax agency. It will not stand up to even just a little shove from a court. Banks don't pay much attention to the trustees, so you get away with it for a while, but you never know when issues might arise. And this sort of trust absolutely will not stand up. The courts have many tools at their disposal to take apart trusts and pierce it. Banks report account activity to the federal treasury or to the finance minister, depending on where you are. Creditors have no trouble finding the person who is the trustee of their own trust. It's nothing more than a house of cards. And you can look at the adverse trustee doctrine, the alter ego doctrine. You can look up fraudulent conveyances doctrine, just the general concept of fiduciary duty, and you can use some search tools with those terms, and you'll find dozens and dozens of cases where so-called private trusts were pierced because the person that was actually trying to enjoy the benefits of everything was the one who was made trustee. The reason why people will want you to be trustee of your own trust is because it's the only way they know how to give you control over everything and still try to receive the benefits of, allegedly on paper not having control by using a trust. There's a much better way to maintain operational control and not be put in the liability prone hot seat of a trustee. Another thing we see a lot is that trust setups will advise people to be the beneficiary. So at least it's not quite as liability prone as making somebody the trustee of their own stuff, but there's still a lot of liability that comes with the beneficiary role as well. Again, the courts have tools that they can use to pierce a trust, and they're looking for situations where they can say that the only reason that you have the trust is so that you can hide assets from creditors. That would be, an alter ego, or if you can show that somebody is both the grantor and the beneficiary, then it could be called a self-settled trust. This is not going to stand. If you're wearing any of the main hats in a trust, the grantor, the trustee, or the beneficiary, and especially if you're wearing more than one of them, there is just a massive amount of liability for you, and the courts have tools to take apart the trust. And this is true even if you use an entity that you own or control to be one of those roles. It's still just an alter ego of you if you're the sole owner and the sole controller of that entity. It gets a little foggier if you have partners involved, but it can still be said to be an alter ego of you. So you have to be very careful who you select, even as the grantor. A lot of people will say, "Oh, well, yeah, I'm the trustee of my own stuff, but I granted it through an entity." Well, it's bad enough that they're the trustee, but then on top of that, they're still going to be called the grantor too. You just look past the entity, and it's very easy for the courts to do that. So when you're beneficiary and you can be shown to have put assets into the trust like a grantor would, then that's a self-settled trust. It's very easy for a court to knock that down. The United States and New Zealand both have carve-outs to protect certain types of self-settled trusts, but these also give up certain other powers that we don't really want to give up. And I mean, if you're in Australia or Canada, just forget about it. So yeah, some exceptions for the United States and New Zealand, but it's really not worth it. Moving on to the ministry thing, a lot of people believe that using a 501c3, or maybe if they're a little bit more savvy, they'll use a 508c1a. They believe that using these as part of their trust system will protect them. However, both 501c3 and the more popular among patriots 508c1a are still just IRS designations. You're literally naming your ministry after internal revenue codes. So that means you're dependent upon the state for the identity of your entity, which means you're giving up a lot of protection. I mean, that's just obvious on its face. And you're giving up that protection just because you want to use a popular template. Um, but it's very important to realize that a 508c1a is not a separate entity from a 501c3. It's not at all separate. All 508s double as 501c3s. The one difference is that a 508 doesn't have to file Form 990, but it's still required to file other informational forms. If it's doing any kind of business, it's required to file all sorts of income tax forms. So anytime an entity or a trust is registered with a government, and it doesn't really matter if it's a public or a private registry, it makes very little difference. Or anytime they register with a tax agency, or anytime your entity is required to file tax forms because you decided to use one of these popular templates, that those things all constitute a contract, which allows the state and federal governments certain ownership rights and oversight over your ministry or your entity. So in that sense, it's no longer private. And anytime you register something, whether it's a public or private registry, you are giving up partial title to that thing. I mean, you can just search that out in the definitions in Blacks. So it should be obvious on its face that you should not be registering anything. That's true of births, of mail, of vehicles. I mean, you may want to use registered mail from time to time, but you want to pick and choose what you're registering. You certainly don't want to register your entities. So we'll show you a much better way how to handle this and to keep everything truly in the private so that you never have to register your private entities with the state. We teach how to form an entity with a deeper basis than these 508 templates or these association templates that are just based on statute. Another question I get asked a lot is, what about offshore statutory trusts and tax havens like the Cayman Islands or the Bahamas or the Seychelles? There's a lot more than that out there, but one of the biggest issues with these types of trusts, other than the obvious fact that they're statutory, is that first of all, you pay a ton of money for them in the tens of thousands of dollars at minimum. And then they just go and change the regulatory environment just because the US or the United Kingdom puts pressure on that local government. So, I mean, imagine if you paid $50,000 for a trust in Cayman and now they're sharing beneficiary registries with foreign governments and they're reporting your transactions back to your home country because of all the new regulatory changes just because Britain put financial pressure on them. I mean, what a waste of money for all the people that paid for trusts in the Cayman Islands. You have no control over what they're going to do with your trust structure that you're paying them an arm and a leg for. So it's totally up to them. But with a private trust system, you're fully in control. We talked about why you don't want to be a beneficiary of your own trust, don't want to be a trustee of your own trust. There's various doctrines you can look up for that. Common law, natural trust, divine trust, they're all insufficient just based on the language that they use and the jurisdiction that they're written. Common law applies very rigid application of laws, and this, you want this trust to last for generations, right? So you pass it down to your heirs, your children and your grandchildren. If it's a common law trust, they can just one up each other with rigid application of law, whether or not they're actually morally in the right. If it's written in equity, then the court has to look to an equitable remedy. And there's tons of case law that we go over in the class about how courts again and again, when heirs are fighting over a trust, they will look to the most moral outcome, which is only possible in equity jurisdiction, gives the judge the ability to go outside the strict common law or commercial law and provide the most moral solution. So we've seen countless people with trust that have these issues. It sits on a shelf and they have no idea how to operate in it. Some guru wrote the trust and now they're unavailable, or the trust just sitting there collecting dust. And second one that we see a lot is that the trust is totally pierceable by the courts. So you need to know how to write your own trust and what the language in there actually means and how to operate in your own trust system. Um, a trust is not a trust if you take your stuff and just give it to yourself to hold for your family. That's not arm's length separation. You can look up the arm's length doctrine. That's another search term. That's not going to protect your assets. It's just like, oh, well, I put my money in my pocket with my right hand and I only take it out with my left hand. There's no trust there. So a court can very easily pierce it and treat the assets as the individual's personal property, tax it to them, have their creditors come after it, use it to settle restitution and everything else. It's a trust that may be legally valid on paper, but operationally it's indistinguishable from that individual's personal wallet, and that is what we call an alter ego, or sometimes a self-settled trust. Now, of course, scripture forms the basis for all of equity jurisdiction. So the Old and New Testament refer to a will and testament, a trust document, and a covenant, a contract, in other words. In Genesis, God entrusts his creation, a man and woman, as stewards, and God is the grantor. It all belongs to him, and he decides the terms which were written down in Scripture. Scripture is the trust contract. The children, the next generations, are the beneficiaries, and man and woman are given dominion and a fiduciary responsibility to manage God's property as trustees, according to his will as expressed in the trust contract. You don't have to have any particular religious or spiritual beliefs to understand and harness the power of Scripture. It is just vital to have Scripture as foundational knowledge. It informs everything you do. And there's a few examples here. Matthew 25, verses 14 through 30 illustrate the mechanics of funding and stewardship. Galatians 4, verses 1 and 2 illustrate the separation of legal and equitable title. Luke 19 also has a whole passage that revisits the parable of the talents and examines some other aspects in it about growing of wealth through good stewardship. So there's a million lessons on every page. I mean, it's just the book that keeps on giving. Our universal right to contract ensures that this trust system is functional and legal and lawful and impenetrable by courts and codes and statutes. These techniques render you judgment proof, insulated from all liability, and completely able to remain private without sacrificing the ability to do business in the public. It's important to understand the history of trusts and equity in a way that serves you to walk in a full understanding of all the principles of contract law in your day-to-day business affairs. It's not useful to just have some complicated trust document that sits on a shelf collecting dust because you have no idea why it was written the way it was written. You need to understand fully all of the language in that trust indenture and why certain words were chosen, why certain words weren't. The world of trust is full of case law history that shapes all the powers and the liabilities involved. And we've done just a massive amount of research to synthesize this history into applicable lessons that give you confidence in operating within the trust system. So deeply internalizing the power of the contract is just the beginning of seeing the law work for your family. Of course, the U.S. Constitution has enshrined contracts in Article 1, Section 10, Clause 1. But everywhere you go in the Western world, uh, the freedom of contract is just a basic principle. It says it right there from a Canadian Supreme Court justice as well. Even though it wasn't put into the Canadian Charter, it's established in hundreds and hundreds of years of case precedents, and you have it straight from the mouth of a Supreme Court justice. You can find the same thing in Australia, New Zealand, South Africa, Ireland, all over the world. And we have students from all these countries, and um, they're all getting the adaptation and the assistance they need. So, you've probably been told that, maxims are set in stone, that if you just whip out a maxim, then the judge has to listen to you, right? Well, maxims always come from case law precedents. You can't really understand equity maxims if you don't look at the history of the Court of Chancery and case law. So it's very wise to take a deep dive on the maxims as they relate to the development of trust law. I mean, we're highly focused on providing you with the best practices, even in the worst case scenarios. And this is dependent on, reviewing case law to see what worked for people and what didn't, and the precedents that have established the powers and the liabilities that guide how we operate. So we provide you with concise, high-level summaries of complicated court cases that you can carry with you in confidence, that you may operate in complete protection. So maxims are not set in stone. Just because you whip out a maxim to a judge doesn't mean you're necessarily even using it right. Maxims are all shaped by case precedents. Really, a maxim is just a summary of case precedents. That's where they come from. It's not a chicken and egg thing. Like you don't know which came first. It's the case law that comes first. The maxim is really just like a witty way of summing up a bunch of case law. So the maxims are shaped by case precedents and they provide a glimpse into history, but that glimpse changes over time depending on judicial decisions, which set the bar for the next generation. So it's really important to look at how the meaning of a maxim has actually changed throughout time before you just whip it out in court or write it into your trust. So that's a big focus of the class as well, but also just some guidance for all of you out there, no matter what process you're using. Don't just rely on a maxim to get you through. You need to understand where that came from and how it's evolved over time. All right. So what is a constructive trust? This is a very important remedy for creditors that we need to be aware of. To give an example, Lulu transfers property to her sister, Cindy Sue, just before filing bankruptcy or discharging a debt with equity, maybe, in order to keep assets out of the hands of her creditors. Maybe she's not very good at equity yet. So the court can impose a constructive trust on the property, which would prevent Cindy Sue from selling it for personal benefit, and the court can require it to be available to satisfy Lulu's creditors. And in other words, Lulu set up a trust in order to protect her property, and the court just goes in and says, oh, that's a nice trust you got there. Actually, you set that up for us. That's it. That's their right. That's literally what they do. So if they can show that it was a fraudulent conveyance that you used to evade creditors, then it's very easy for them to just constructively change the beneficiary of the trust. Oh, that was very nice of you to set up that trust for us to pay out your creditors with. We're just going to change some things around to make sure it matches what we're telling you you really intended. It's an equitable remedy. It's one that's used against us all the time. Um, it's nothing new for people to transfer assets to friends or family members or trusts to avoid creditors, and courts are on the lookout for this behavior. It just depends on the facts of the case. I mean, the court could allow the constructive trust, or it might not if it deems, maybe the new owner of the property would be harmed in some way, or maybe both the new owner and the previous owner might both lose, and it still goes to the creditor. There are many actual and hypothetical examples of this. So when I say that we teach the best practices on worst case scenarios, a lot of that involves how to never, ever have this happen to you. Very, very important. Now, the tax agencies, both at the state or provincial level and the federal level, can have enhanced powers to reach trust assets compared to just normal private creditors. Even when a trust is properly structured, private irrevocable trusts may still be vulnerable in certain situations. So this is one reason why we're so particular about best practices, some of which include maintaining arm's length, never wearing multiple hats, keeping the accounts separate, not underfunding if you have a business going through it, observing the normal formalities of holding regular meetings, Those are just some of the basic best practices. By not wearing multiple hats, I mean, you shouldn't be the grantor and the trustee, or the trustee and the beneficiary. In fact, we teach you how to operate in total authority without taking on any of these three liability prone roles. But I mean, if you're just kind of doing your own thing, just at least make sure that you're not wearing multiple hats. Um, of course, there are some statutory trusts that are set up to where somebody does wear multiple hats and there's like a specific legal reason for it. But again, you give up a lot of powers to do stuff like that. If you're really trying to protect your stuff, you do not want to wear multiple hats, and really you don't want to wear any of the main hats. Um, so we can show you how to maintain operational control without having to do any of that. We decided that it is in the best interest of the students to require that they take the Honor with Equity class either before or concurrently with the Equity Trust System class. And this is because in the Honor with Equity class, you learn everything that you need to know about how to deal with tax agencies honorably, and and how to get them paid. Of course, not using banknotes, but still, honor them with a very particular type of negotiable instrument that they do actually use to get paid. So we required that as a pre or co-requisite, because if we didn't, then we'd have to spend a lot of time on tax loopholes. Of course, a loophole is just a dirty word that somebody came up with for somebody that they were jealous of, who is using good practices in order to save money. Most trusts are designed almost exclusively with all sorts of tax loopholes, and you have to spend months studying all sorts of crazy um, red tape, basically, things that have nothing to do with human creativity. They're just ways of getting around bureaucracy. And they sacrifice a lot of benefits and powers for, obtaining certain tax privileges. They report to the tax agencies. They put their finances out there in the public. And some of these very complicated structures, I mean, they can be very expensive to set up, but they can save a lot of money, and if you're doing business. But there's a better way. And since we can take care of taxes honorably with the information that we teach in the Honor with Equity class, then we can just skip all that stuff and concentrate on getting you and your family and your family's business up and operating in the private without sacrificing any of the full breadth of 700 years worth of case precedents that have established many, many, many trust powers that you would give up by using tax loopholes. The trust system class will go into detail about the purpose and use of each trust. We teach to use multiple trusts layered together, working together in tandem, as well as how they all work together and convey to each other, and just how the whole system works. The basic idea is that you want to separate assets into different trusts as much as possible in order to offer the most protection from liability. Depending on the jurisdiction you live in, though, the need can arise for some highly specific customization. Some states and provinces are extremely aggressive in trying to claim jurisdiction over privately held assets, especially property or real estate, and they have established local specialized case precedents against trusts. So sometimes it's required to use a uniquely tailored entity structure. Um, and so we look at each student's situation and get them what they need for their area. That may sound very complicated to some of you, but I really enjoy adapting the material to each different area. I find it quite fun. So we go deep into all of this in the class, and trust me, it was no simple undertaking compiling all that information. I mean, we have students across the Western world, and even if we just have like one guy in Ireland, we're still gonna, fully adapt the information to what he needs. So while it may seem complicated at first, we break it down and we give you plenty of resources to make it applicable to your situation, and help you to just laser focus on what you need. So the trust indenture is the main trust contract, and you'll need to learn several key components in order to even begin writing your own. There are many different kinds of trusts, but there are some key principles that we teach which will equip you to discern the common threads between all of them and begin to determine which will serve you best in each situation. There are trusts that we can layer into our systems that are for very specific uses. For a very basic example, you might have what's called a special needs trust. It allows for provisions to take care of the needs of a family member who has ongoing special needs, and in a way that doesn't affect their income that might jeopardize their government benefits because with somebody with special needs, they're receiving assistance from the state. There's a lot of regulations about their income level, and so the trust gets things out of their name and still provides for them, so it doesn't affect their benefits. So you have to be careful with the disbursements for a trust like that. We also touch on the very gaining in popularity, the infinite banking concept, very popular among libertarians and just very savvy business people. Infinite banking concept, of course, uses whole life insurance in order to basically make you into your own banker. So we touch on this and we talk about how to combine its very lucrative life insurance policies with a trust system. There are classes which allow a trust a great deal, clauses. There's clauses which allow a trust a great deal more flexibility and protection. And so we dive into these in a lot of detail. It's not good enough just to understand them. You have to actually be able to utilize them when the situation arises. If you're talking with your bank manager or an investment firm that your money's tied up in, if you're dealing with receiving royalties, if you're dealing with a crypto exchange, there's clauses that allow you to move things around rather rapidly and even change the jurisdiction of the trust. But you need to know how to present this to the bank or to the exchange or whoever it is you're dealing with. You can't just go in there and, you know, spout a bunch of freedom stuff. I mean, they're not gonna go for it. You have to know how to talk to them very professionally, and everything that we're doing is above board. So we teach you how to make it sound like what it is. Everyone's situation is different, and there are limitless possible scenarios, but we prepare you by following the absolute best practices and worst case scenarios, and then you'll just be ready for everything. Why leave anything out? So, as I mentioned, we run into people all the time who have a trust, but they're not even using it. The papers are just sitting there collecting dust. In fact, the first trust class that we ever took, we purchased trust documents from that teacher, and that very thing happened because we had no idea how to implement it into our lives. So we've made our system to be usable, applicable, and just a benefit to you and your family throughout the generations. Often we have to learn to talk about the need for a trust with our families and friends because we're not taught these things like members of wealthy families, just learn it from their childhood. This is partly why we spend time on the groundwork, the history, the vocabulary, the maxims, the case law, as well as some very colorful stories to tell your family and friends, which will just help illustrate the importance of trust and get the family on board. It's really for everybody. It does. You don't have to own a business. Um, so we teach the actual how-to of what to do if you get a presentment from a tax agency, how to deal with the banks, how to exchange property or vehicles or other assets into the trust, how to do the accounting and cash flow for your trusts, just according to the very best practices to fully protect you no matter what comes your way. It's basically like running a small business. Everything we do is commerce anyway. So if you pay bills, if you own a car, if you own property, if you receive income, if you want to know how to be your own banker using life insurance, then all of these things are doing business. You are running the business of your life. So this information is going to be applicable to whatever you have going on so that you can bring it into the private and have it be protected. Business owners will see specific strategies, and we tailor those strategies for whatever industry they're in. No matter how heavily regulated the industry is, we always can provide a solution that makes things just far more private and protected. But even if you don't own a business, you're still doing business every single day that you operate in commerce, and you're going to be better off knowing how to do so privately and with minimal liability. So I'm going to harp on it because it's super important. You never want to be the trustee of your own stuff. That would defy the very definition of a trust. And yet, this is the situation of so many. The courts will deconstruct that trust and call it an alter ego. So you may be able to get away with operating in it until the heat is on, but if it's ever put to the test, it is going to crumble. Um, so surely your family's livelihood deserves better than rolling the dice on that. We spent an entire class session and then some on the very important role, the all important role of the trustee. Our students get to know each other so that they can act as trustees for each other. Of course, an equity minded trustee is going to be the best around. And the Freedom Studio Trustee Network also has started a group for this purpose as well. Um, it's a fiduciary role and obviously critical to the entire concept of a trust. Much of trust law and case law precedence centers around the trustee. So you can either comb through 700 years of trustee case law precedents or simply let us do it for you. We'll teach you the ins and outs of operating as a trustee to keep everything in the private and out of the statutory realm. There's another really important role called the trust protector. In some ways, they can have even more power than the trustee. It's an extremely important check and balance to the trustee, and the trust protector has a massive amount of case law behind it as well. And of course, we go deep on this role too. We do not hold back on giving you the step-by-step instructions you need to perform a private conveyance of any kind of asset you have. And these instructions will be shared on screen and they'll be available for download for future use in the classes. There's no one book or one source for all of this information that we've compiled for our students. Our class is the only way to access all this information in one place. There are as many different possible scenarios out there as there are families in the world, but we have still managed to distill the steps needed to convey and protect all assets anywhere in the Western world. So we supply you templates and detailed lists. We show you the common threads between all conveyances. You can choose to do it yourself, but we are also available for private coaching and ongoing support to help the students put it all together. Now, the equity trust system can operate just fine without the use of a PMA or an SSM or corporations. In fact, a business trust that's properly set up and executed can do more than any of these other entities. However, we do find that people really like these other entities, or they already have them, or they may have specific uses for them, so we still include them in our class. All of these entities can be layered within the equity trust system very easily, and some of them, I mean, they all offer their own advantages and drawbacks. PMAs are good if there are many members to deal with, and maybe you have students or patients or something. And they can also be started with only two people instead of the usual three for a trust, so that's an advantage. They can flow through to the rest of the trust system and just act as a pass through, and there's other uses for them as well. Self-supported ministries are good if you have a spiritual or educational mission or purpose. They're most valuable in the United States. Other countries like Australia and Canada do give a few benefits to ministries. It varies based on what state or province you're in. Um, but they don't grant the same level of protection for a religious ministry as the US does. But these can also be started with only two people, and there are some clear advantages in certain situations. Corporations, or the Australian version, the proprietary limited, have very unique use cases, especially if you do business in a heavily regulated industry. And there are also some very clever uses of limited partnerships and certain types of corporations that can be layered within our trust system in very creative ways. This is something we've added to the class, so any of you alumni of our previous equity trust system classes Just know you're going to have some amazing surprises coming up for you in the next class series. We cover absolutely everything you need to know to add these into your trust system if needed. It can vary wildly depending on where you live, but rest assured, we will cover it all. As we said before, you could write a 40-page document, and if it's sitting on a shelf collecting dust and you don't know how to operate through it, then it's pretty much worthless. And then on the other hand, you can write a trust on a napkin and operate it perfectly if everybody involved fully understands what to do. So it's all about the language. If you're going to write a trust indenture and shoring up that gap between the knowledge of the operators of the trust and what the optimal operating conditions are that you can spell out in the trust indenture. So to keep your trust contract, your indenture in equity, requires very specific use of language and maxims and case precedents. You cite maxims and case precedents to guide the actions of the trust operators. Once you write the parts dealing with the more technical issues of assets and conveyances, you can go back through and consider how equity, the maxims, the principles, the case law, might be added in order to bring that spirit of conscience into the everyday decision-making process so that you're always operating according to the very best practices, which also afford the most protection for you. So it's really a commitment to equity jurisprudence. We want to advance equitable ideals because they are the most moral, but also because they provide the most protection when we act morally. The power of a trust indenture is not how complex we can make it, but rather the power is in its use of is in its equitable capacity to balance rights and remedies with compassion and fairness, and utilize the many precedents which grant us the power to do so. It's also a live working document. It should not be set in stone. A trust indenture should be a living contract for your family and become the law for your family. So equity embodies all the principles that we want governing ourselves and our families, and it'll also keep the heirs from using strict laws to one-up each other like they might be able to do with a common law trust. We take a real hands-on approach with the class. Even though it's a great deal of new information, which can feel complicated at first, we take you through it step by step. We offer real-life examples of how others have applied this in their lives. We take you through scriptural and historical examples, stories, and case studies, which offer great foundational encouragement. One of the most valuable aspects is that we take volunteer students from the class who will offer the details of their family's finances and businesses, and then we'll plot out for everybody how the trust system would work in their lives. We actually diagram it all out live, and we talk through the details and the resources and how things will flow together through the system. It's a really interesting component to the class, as we've gotten situations varying from computer programmers to farmers to construction businesses to Airbnbs, tow truck companies, doctors' practices to ministries and yoga studios. It's really fascinating and really helpful for our students to see how this system has the versatility to smoothly operate in so many different situations. And this helps the students learn the full scope of unique customizations which different industries and areas of business need. We all learn from each other, and the class is really so comprehensive that our students can go on to write trust for others after they fully internalize the class material. They don't need us anymore. Of course, we are always available to provide support anyway. We take pride in the fact that our community just keeps on giving through our continuing research and application of the class material and the input of the students. So we find that the students are in all different phases of learning, internalizing and applying this information to their lives. And once a student joins the classes, they have free access to any future iterations of the classes, and of course, continuing access to the Telegram group and to us, myself and my wife, for getting their questions answered. Anytime a need arises, we all come together and help. It's our passion, and so we are continually researching and applying new concepts to our classes and our own lives so that we can bring the most updated information back to our students. And we share the wins, we share the successes, and if something ever changes in Babylon, as it does from time to time, we are able to get that new information to our students rapidly. So I'll be happy to take questions in a minute, but that is it for the workshop for today. I hope you learned a lot about what not to do. And if you really listen closely to the words I use today, you're also going to be able to glean quite a lot about what to do, even if you don't wind up taking the class. If you listen carefully, there's quite a lot that you can glean. I choose my words very carefully. This presentation has also been about giving you a detailed overview of all that the equity trust system class will provide for you and how it can be put to use. We don't just teach how to write an entire trust system and customize it for your jurisdiction. We also teach how to operate in it day to day according to the very safest practices and most powerful techniques. There is a dizzying amount of information out there about trusts, and much of it is either statutory and so not so private, or it's just bad advice, like telling people to wear more than one hat or be their own trustee, which will simply not hold up under any kind of scrutiny. I gave you several doctrines of law with many corresponding case laws that you can case precedents that you can look up in order to prove that out. So we have found a way to gather and encapsulate all the information you need in one place to be successful in protecting your assets for many generations to come, no matter where in the Western world you live. On the screen, you'll find our contact information, and when you sign up, let us know that you came through the Freedom Studio. Thank you all so much for your time and attention. We pray that this was edifying for you, and we bless all of your endeavors in the future. And of course, we have time for any questions now as I pass it back over to David.
Thank you so much, Julian. Appreciate that. And great presentation as always. Very powerful, very insightful. So we are going to move to Q&A. This is your opportunity, in particular, those of you who are live here with us in the actual Zoom meeting to ask your questions. I also posted all of the contact information that Julian shared on screen in the chat. So we don't have to have it on screen, but you guys can quickly go there if you want to go directly to their website, if you want to email them, or if you're on Telegram, whatever you feel is going to be the easiest way to get in touch with them. Also, you can ask me or anyone on our team questions about it if you're already in touch with us. If you are on or will be on a consultation or in a study session with us, of course, you can always bring up questions there as well. So here's how we're going to do it, just to maintain a little bit of decorum. I'm going to ask you to raise your Zoom hand. Some of you will have gestures enabled, so if you raise your hand on camera, your Zoom will automatically raise it for you. Not everybody has that advanced feature enabled, so the easiest alternate way to do that is to look at the bottom of your screen. Hopefully you're on a desktop or laptop to make it easier, and there will be a raise hand feature. It'll either be its own button or it may be under reactions, depending on the version of Zoom that you're running. So if you would like to ask a question, go ahead and raise your hand, just like Ken did. In a minute, I'll go around and start letting people unmute themselves and ask questions. If you have many questions, just start off with one at a time. And then obviously if we don't have a lot of people raising their hand, if you want to ask another question, we just want to give everybody an opportunity to ask specific questions. So having said that, let me make sure that I can give you guys the opportunity to unmute yourselves. And let's go to Ken with your question.
Hey, Julian. Thank you and David both for the work that you're doing to help liberate people from Babylon. That's really beautiful work. I just wanted to briefly share a trust structure that I had been introduced to by a mentor over the past few years. That I'm not saying this structure is right or it's the best or anything like that. I'm just literally with an open mind wanting you to kind of briefly comment on the weaknesses of such a structure. because I'm sure you probably have quite a command of that. So basically, it's a structure where the owner of all the properties, the grantor, I guess, creates a parallel trust to the SESQ trust that was set up, at the Federal Reserve and the Treasury and all that, and they assign themselves as the beneficiary of the trust, and the president and the secretary of the Treasury as the trustees, and then they basically uh, file their status documents to say that they're separate from the capital letter name and they take control of that. And there's kind of some UCC documents that go along with that and a DBA that goes along with that. But then essentially you go to the bank and you use your capital letter name and you open a bank account and a business bank account and you start using that, et cetera, et cetera. So I know that's a really watered down version, but
Sure.
I don't know if you've heard of a structure like that before.
Oh
It's
yeah.
kind of like a secured party creditor structure
Right.
because you
Yeah,
do
it's
use
pretty much to a T, the secure party creditor process.
right.
Um, yeah, the secure party creditor process has been around for about 30 years. It arose out of the, accepted for value and redemption stuff that was going on in the mid to late 90s with Roger Elvick and Sam Davis and Qui-Tam and all these kind of guys. Um, there's a lot of good there that we all stand on the shoulders of giants. I believe that we've taken certain aspects of that process that did work for them and kind of left a lot that didn't work. Obviously, people wouldn't still be using it 30 years later if it didn't work sometimes, right? But when it comes to declaring yourself the beneficiary of this, mysterious account that was set up at our birth, you've been acting like the surety all your life. You got the birth certificate, you got the social security card or the social insurance number if you're in Canada. Um, you can try to say, oh, well, it wasn't a conscionable contract. I was just a baby. I never agreed to this. How could I agree to this? They didn't tell me about it. But at the end of the day, as you grew older, you began to perform on that contract. You use those things to obtain a bank account, to obtain a driver's license. You use the driver's license to fly on a plane or to rent a car or to get insurance. So, you've been made a voluntary surety by those contracts, the birth certificate and the social insurance number, social security number. And then you went and acted like the surety by using them for their stated purpose. So for you to just all of a sudden send out a bunch of status change stuff and say, well, I'm the beneficiary now, and name, tell the president that he's got to be your trustee. Um, I think it works sometimes. I've never seen it work for very serious cases. I've obviously have seen it work for like traffic stuff and, maybe, minor civil cases. But it's not something that I've seen have the consistent efficacy that we see with the equity process. And as far as protecting your assets, I mean, what you just described is basically akin to a status change slash secure party creditor process that people use to try to discharge cases. It's not an asset protection scheme. So it would do nothing to protect your assets. Uh, People try to use it to get cases dismissed and with some limited success. So that's how I would break that down.
Yeah, I don't see the protection because my name is still on everything and the bank account's still tied to my social security number, and they could certainly locate me very easily for liens and levies. So I really
For
don't see
sure.
the huge protection value now that I'm knowing more about trusts and equity. But
Right.
one last thing on this, I'm sorry. The biggest fear I have is just like if I do get approached by, with a presentment by the IRS to actually admit to them, that I have that debt, even though I've not filed a return or anything. That's the part that I struggle with. And David and I have talked a little bit about that, just the fact that I know that we can't be contentious. I know that we're not going to argue back and say, no, that's not my dad, that's not my name, all that stuff. But we are agreeing essentially, to accept, their presentment in a way. I mean, I know there's more to it, and you're not actually paying out of your own funds, but it's just a scary proposition. to put yourself in that vulnerable position in front of a judge in a court and say, yeah, I'll accept that presentment of
Well,
debt.
I think, yeah, I get where you're coming from with that for sure. It's a lot to wrap your head around, but I want to kind of just distinguish the difference between agreeing and accepting the way that we would do in equity. We're not exactly agreeing. What we're doing is assenting, which is, we're really just authorizing the transaction to go forward as an accounting matter. Consenting, consent, acquiescence would be saying, yes, that's my debt. Oh, yes, I've been very bad, and the court needs to have jurisdiction over my life. Assent, which is what we're doing, is really just saying, okay, well, I see you have this balance you think you're owed. Here, let me give you something you can use to help you with that. Because my signature is, the source of original issue for commerce. So you need me. So let me help you out, and we can settle this together. So that's really what you're saying to the court. You're not consenting to anything. You're just, with equity, we treat everything as an accounting matter. And, if you look it up under the definition of discharge, under the subheader equity practice in Black's Law Dictionary, you'll see that equity makes you the accounting defendant. And so it's really just an accounting matter when we accept. It's not like you're saying you're guilty or something like that.
Thanks, Julian.
Also, another thing is we've never had an IRS case go to court once the student began bringing equity.
Great. Great questions from Ken. Let's go to Danny with your question.
All righty. Great presentation, Julian. Appreciate it. My question is centered around the dynasty trust. I've heard this term come up over the past year. Various people are talking about it, and they usually, when they bring it up, it's usually around the concept of the what is the term? Diplomatic immunity. And I'm just curious to know, is the process that you're showing, does it tie into that in any capacity, or is that just something in left field?
Well, I'd say the diplomatic immunity part's out of left field, but there's a lot of applications of a dynasty trust. So you can have a statutory dynasty trust. You can have, a private dynasty trust where somebody's trying to combine a diplomatic immunity process with it, which it sounds like is what you've been exposed to. It's basically just a trust that has no limitation on its lifetime. So it continues on in perpetuity. It's usually set up in Delaware, which will afford it the greatest protections. It's usually statutory, actually, but it's set up in a very favorable jurisdiction of Delaware to help it out. It doesn't. We incorporate some of the principles of the dynasty trust in the trust system we use, but we go a lot broader and deeper on the overall powers and liabilities of the trustees in order to just provide a fuller scope of techniques and strategies to you. Also, a dynasty trust tends to just be one or two trusts, whereas we use multiple trusts working together in tandem to separate everything out. So there's a lot of little differences, a few big differences. As far as the diplomatic immunity thing, that's kind of a separate process that sounds like is being combined with the dynasty trust. I have friends that have tried the diplomatic immunity thing and wound up getting arrested, but perhaps you have a more professional teacher for that. I'm not sure, but hopefully that helps.
All right, great question. I'm going to just, before I go to the next person with their hand raised, I'm just going to also intersperse a few questions coming from the chat, just to make sure we don't skip over those. So the first question that I'm seeing here is, how is all of this, meaning the trust system, applicable for Bulgaria in Eastern Europe? Julian, do you want to speak to that?
Well, I think that we could certainly make it applicable to Bulgaria. You would be my first Bulgarian student. So, as I said, I very much enjoy adapting the material to different parts of the world. It's one of my favorite parts of this. So we would work with you intimately on that and get you absolutely everything you need.
Okay, great. And let's go to Oksana with your question.
Yes. So I'm looking for a practical application here. Let's say Let's say we have a primary home with a mortgage and property tax. And the property tax is assessed on the, not on the value you purchased it for, but for basically unrealized gains. You received the bill, and my question is, in order to at least engage or look at discharging the property taxes, what is the order of steps here? Do you need to place the home in a trust first, or you can work on the process in equity?
So there's a couple of issues that would prevent you from dealing with the property taxes right away, unless you want to just take on a bunch at once. First of all, the mortgage contract poses two issues for you here. The first one is that you have to pay the property taxes according to the mortgage contract, or else the mortgage contract has been violated. Equity can be applied to property taxes and it can be applied to mortgages. You know, we've discharged both. But they're both serious issues and they both would be handled separately. You know, the property taxes would be handled with the county and the mortgage would be handled with the banks and eventually with a court. So that would be two quite large issues to take on at once. Certainly not something that I would recommend just because of the amount of work involved. Although once you're a pro at equity, I'm sure you could do it. So that's one thing. And the other issue with the mortgage contract is that it's going to have most likely what's called a due on sale clause, which is going to prevent you from transferring the title into a trust. Now, if you call your mortgage company, you could work something out with them where they're probably going to allow you to use a statutory, what's called a living trust, which, you know, the word living is connoting a little bit more than it sounds like there. I mean, usually a living trust is just one that's formed during the lifetime of the grantor. But when you see a capital L living trust, it usually means it's like a statutory trust. It's written by an attorney. It's grantor controlled. It's revocable, and it has several other characteristics usually.
Right.
So the mortgage companies will allow you to transfer into a trust, but they're always going to want it to be a statutory living trust written by an attorney, registered with the state. There's some benefits to that. I mean, it gets your name off of the property tax roll. It makes things a little bit more private. And of course, it would skip estate taxes. God forbid that would be an issue. But of course, there's just severe limitations compared to a private trust. But I would do it. I mean, I would get in touch with the mortgage company, and you're probably not even going to have to pay property transfer taxes or fees depending on where you live, because a revocable grantor controlled trust is just taxable to the grantor anyway. And since it's already in your name, they're probably not going to, most jurisdictions don't quibble about the difference. So that would be a good option in the meantime. And when you get the mortgage paid off, then you can do whatever you want. You know, you can transfer it into any property. But that due on sale clause in the mortgage contract is going to limit you for the meantime.
So even if you, let's say you transfer the property into a trust, you can't just do a quick claim and let's say not record it.
Well, I mean, you can always have what's called, you know, secret equity or hidden equity, you know, and just have everything off the books, non-recorded. That's certainly possible. But if you ever needed to bring that claim forward while the mortgage was still in place, then you're going to have issues.
Right.
So, you know, it's really the mortgage contract is really what's limiting you there. And I'm not sure you're going to see much benefit of hidden equity again, maybe just for estate planning, which, you know, the statutory trust can help you with anyway. So
Got it. Well, thank you so much, Julian and David.
absolutely.
Awesome.
My
Awesome.
pleasure.
Okay, before I take Tara's question, I'm just going to read one more question that came through our live on social media. By the way, we currently have 31 people watching on social media, so thank you everyone for joining on that side of the fence as well. The first question that came up, I'll just rephrase it a little bit to make it a little more concise or a little more clear, but basically the gist of the question is, how can one go about putting into practice this kind of equity trust system if they have a spouse who just maybe is, in their words, indoctrinated, maybe just not really comprehending this and may potentially not be on board with it?
Well, first of all, I mean, when you join the classes, you get access to a trove of study materials. And I mean, we take you through the primary source information. I mean, we go to the same law books that are going to be on the judge's shelf, the same acts of Congress or acts of Parliament, depending on where you live, that you can just show your spouse, like, look, this is what the law says. This is what the dictionary says. So you're going to be able to walk them through, the war powers, the bankruptcy. I mean, you're gonna be able to stand in confidence in all this stuff. I mean, if your spouse has a problem with it, it's probably because you're getting like bits and pieces from, various teachers out there that probably aren't explaining things very well, and then you're not able to explain it very well. But like you have the discernment to know that you're getting at the truth and that there's something wrong with the way that we're taught. But you're lacking the ability to express that discernment into a proper, argument to convince somebody. So we can equip you with the primary source materials and the analysis that you can use to confidently stand on this and win over your friends and family to what you know is the truth. But if your spouse is just totally obstinate, then it depends whose name's on the property that you're wanting to convey into trust. If both your names are on it, then obviously you're going to need that person's consent. Dealing with tax agencies, you can file, they can file separately if they want to do that, and then you can bring equity to it. So there's ways to still operate, with a hostile spouse. But I would much rather you internalize the class material and take the opportunity to win that person over.
Yeah, and I would just add like my flavor or my way of addressing that question, which comes up a lot, is we it's really better to be the example than to try to, shove information down people's throats or, hey, you got to know this. Like sometimes people get very enthusiastic when they realize, like you said, something is wrong. But then, like you were also saying, Julian, we don't often always have the full picture. So it's better to just quietly go about educating yourself and then start embodying what you're learning. So embodying those principles, and that will actually probably have a more profound effect on those around you than if you just start going around, espousing concepts that you may or may not know very well. So that's kind of how I look at it. We've all been guilty of doing that, by the way. I mean, probably everybody in the Patriot movement has, through the enthusiasm and frustration of discovering, how much they don't actually know, has probably at least committed that, error once of trying to oversell a concept that they haven't fully embodied. So I'm not ragging on anyone because I've certainly done that. But the higher level, the higher minded way would be to just start to quietly go about learning what you need to learn and then embodying that and being an example. And that will probably rub off, especially off of on a spouse, children, people closest to you. That will probably have a profound effect on theirs. So having shared that, let's go to Tara along with your question.
Hey, thanks, guys. Thanks, David. Thanks, Julian. Really great presentation. I have been studying trusts for a while now, mostly in the common law jurisdiction. I'm currently writing a trust. I have a PMA, and I'm writing a trust to include the PMA as an asset. And was thinking about, having my PMA be one of the roles, right? So I'm curious, just if you could briefly share, I know this would be in your class and I know it's more extensive, but how you are not, one is not any of the roles and yet has the complete authority over the trust. I'm curious if you could just briefly share about that, if that's possible.
Let's see, is that possible? What'd you say? Yeah, it's part of the layering process, basically. There are other roles than, grantor, trustee, beneficiary. And a PMA can be helpful with that. A PMA, of course, is run by a board with many people on it. So that can help. I mean, there's a lot of trust law basically to show that there needs to be a preponderance of independence among the trustees in order to properly operate the trust at arm's length. So, I mean, if you're, one member of a board, and then perhaps there is enough independence on that board to constitute what would be an arm's length transaction if that PMA were to handle trust affairs.
PMA flow to the trust.
It's probably better to have the PMA layered with the trust in such a way that it's, flowing assets down to the trust as opposed to have it, sit in one of the roles of the trust. But there's advantages and drawbacks to both.
Okay, thank you. Appreciate it.
Sure.
All right. And while we're waiting for people to raise their hand, I'm going to just go through a few questions that came either in the chat or reposted from social media. This next one is not really, may or may not be specific to trust, but I'll just go ahead and try to phrase it in a way that we can address it. So it's actually quite an expansive question. So really you can comment anything you want, Julian. They were asking, what have you learned about the registration of your live birth, the social security number, and how this ties into our lives and our trusts?
So yeah, it's a very expansive question. Because it's just an expansive topic that nobody's really been able to rein in fully, at least to my satisfaction. Yeah, there's a lot of processes out there that brush up against the Social Security number account. They do things with bonds, they do things with claiming securities, they do things with the UCC, and they seem to get indications. Sometimes they even get checks from the Treasury Department or the Minister of Finance or whatever, which seems to indicate that they're doing something with this account, but they aren't quite able to articulate what it is in the most technical terms. They can't say who's stewarding the account. They can't say where the account even is, or what is the mechanism by which you pay into or draw from the account or use it for set off and adjustment. So it's a very mysterious topic, but there's a number of things that do indicate that there is such an account. There's people have pulled CUSIP reports on courts and shown that somebody's social security number or social insurance number can be linked to a court case in such a way that is attached to bonds being traded on the open market, drawing a profit, and then reverting the profit back through the court registry investment system, which you can trace out through actually United States codes, to return the profit back to the court. So in some sense, they don't exactly try to hide it, but it is not well researched and understood. So I can just tell you that we have enough evidence to point to it indirectly, and it's not something that I directly get involved with because I'm not able to provide the kind of robust process surrounding it that I would like to. I can do that with equity. I can break down for you exactly how and why everything that we do works and where it all comes from, and take you through all the primary source materials, and that is the kind of robust, comprehensive analysis required to satisfy me, and that's the only thing that I would ever deliver to my students. But I do know that such an account exists. I know it's out there, and I'm sure that with a few more years of research, there may be some better analyses that are put forward.
Excellent. Excellent. Great insights and great answers, Julian. I love your focus on practical, grounded approaches. Like really, that's very important, is having something that's actually, process driven, repeatable, backed up. I mean, isn't that what we're really looking for ultimately? I mean, sure, anybody can, shoot darts and just wildly and hope they'll hit the target, but if we can come up with something more, more robust, wouldn't that be the preferred route? I certainly feel like it is. So appreciate that answer. Yeah. Okay, and I don't see any hands raised, so I'll just keep going through the questions that are coming through social media or through the chat. So the next one has to do with an EIN number, or any kind of federally supplied tax identification number with respect to a trust for banking purposes. I know you obviously go into that a lot in the course, but the general question is just is an EIN number required, and how does that kind of fit into it?
Usually it's required. There are some people who are claiming to be able to set up accounts without an EIN, but and I've talked with them, but there's, they don't have the experience of running a business through it and having large amounts of money going through this kind of account. So I'm hesitant to embrace it. And I just have hearsay that it's possible without an EIN. However, we have it set up in such a way that it's not your social security number that's attached to the EIN. If you're in the United States, you will still need an EIN, but we can do it in such a way that you are totally separated from that whole process. And we have a way of setting it up with the IRS and with, just for the EIN alone. And the only reason we do that is so that we can set up the bank account, and then setting it up with the bank in a way that you are totally private and protected. And if you're in Canada, you don't even need anything like that. So as long as it's a non-interest bearing checking account. So it just varies depending on where you are. Australia is a little bit more stringent about certain things. But no matter where you are, we can set it up in a way that provides you the absolute most privacy and protection.
Yep, and I can also back that up because some of the trusts that I've been involved in setting up, we have also obtained EIN numbers without using the Social Security number. So, yeah,
Exactly.
that's a good insight. Okay, next question that came through the chat here from Don is, does your course, and I'm assuming he's referring to Honor with Equity in this case, does your course Honor with Equity teach how to discharge a home secured line of credit?
Yes, but it's basically going to be the same as discharging a mortgage, meaning it's going to be, quite intensive. You're going to need to use all the tools and, make sure that you have fully internalized the class material, because it's probably going to go to court and you're going to have to be able to speak properly with the judge, which is something we cover in great detail, but it just takes time to study and make sure that you've internalized it.
Okay, and another question hot off the press from social media. What are your thoughts on unincorporated business association trusts? Like I guess he means a UBOT or a Massachusetts type business trust, which incidentally I learned about before I learned about the equity trust system. So I'm just curious what your thoughts are on that.
Excuse me. Well, the Massachusetts style trust is, something that, shares some similarities with ours. It's certainly, it's got a lot of the powers that we're looking for, but of course it's still, dependent upon Massachusetts state law. And it's a business trust, which is very useful. I mean, we of course use business trusts. The UBAT, I mean, if it's incorporating like an unincorporated association with the trust system, most of the way that people teach unincorporated associations is that it's required to be registered with the state, and it's like a private register for religious associations as opposed to a public register, but it's still registered with the state, which is a huge problem. So I don't really recommend utilizing that particular type of entity. Now, if the UBAT is like its own thing that is just totally different, I couldn't tell you. I mean, there's a million different types of trusts out there, but that's just my experience with UAs and Massachusetts style trusts.
Awesome. Awesome. And just while we're waiting for more questions to come in, and we'll do, if necessary, we'll do the last call. We might have a few questions. I want to ask you just briefly, by the way, we currently still have 29 people watching on social media, plus everyone who's here. So that's fantastic. In the meantime, if you guys could just share a little emoji love for Julian and Standing on the Rock, and just, if you're getting value from this, just share a little emoji love, that whether you're on social media or here on Zoom with us. If you're finding this to be of value, we appreciate that, just so we can get a little bit of feedback. And of course, if you find it's not valuable at all, that's okay. You're not going to offend us. You can let us know as well if you want to give us 1 out of 5 stars for some reason, and hopefully we'll figure out why that is. But I suspect most people are getting good value. So looks like in the meantime, I did see somebody's hand raised, but they lowered it. Oh, there we go. So let's go to Sean with your question.
Are you
Go
able
ahead,
to hear
Sean.
me? Can you hear me?
Yeah, we can hear you.
All right. I'm not sure if what I'm about to ask you will be covered in your situation, your course, but I said I might as well just throw it in. All right. Does your, I guess, your equity program, my aim is to be absolutely left alone. Um, my aim in life is not to gather dollars and FRNs and things like that. I just want to actually get out of the entire system and just be left alone. So if I'm in a system based upon a contract that I never wanted to sign or anything like that, and I've been going through life with all this unknown contractoria. I've now done my status change. I have my passport. I have all these things. I've given away my driver's license. I've gotten rid of everything I could possibly get rid of. And I wanted to know, does this equity, is there a method or does this even work with it? Or is it just something totally different than what you're showing here? To where is there a method to be just absolutely left alone? Leave me on the dirt and let me walk the earth and be left alone.
Yeah, absolutely. The equity that we teach will provide you with the best possible tools to do that. It's, my recommendation to my students is that it's nice to be able to operate in commerce. We teach how to be able to do so while being completely protected and private. But of course, we also have some students like yourself who they're just done with it. And they're like, I don't even want a bank account. I don't want a driver's license. I don't want vehicle registration. None of it. I was tricked. It's BS, and I don't want to deal with it. So the class the equity class will provide you with the tools that you need in order to unmake those contracts that you mentioned from the beginning as if they never existed. And then it's just going to come down to you standing on that if you're ever challenged. Excuse
Okay.
me. I mean,
All right.
you're going to be dealing with that regardless of whatever process you use, Sean. You're going to deal with that every time you're pulled over, every time you want to fly on a plane, every time you want to, maybe you want to go inside a federal courthouse for whatever reason and witness a case.
Who wants to go in a federal courthouse?
It's fun. It's fun to go to court and see how they do things. It's good experience. But no, I mean, if you want to travel and fly on a plane, I mean, international travel is going to be out of the question unless you have like a special relationship with, somebody in a position of power in another country that can get you in. Domestically, you can do it. I mean, I know a guy that, uh, this would be what I would call the strictest application of exclusive equity is what you're describing. And I know a guy that actually does fly domestically with nothing but a family Bible as his identification. So it
That's
is
really
possible
great.
to be okay domestically, but I think international travel is pretty much out of the question. And then whenever you get pulled over, the officer's still going to see the old man when he pulls up your information. I mean, they have your face, they might have your fingerprints. I mean, they got all sorts of data on you, and they're just going to see the old man every time. Now, the equity we teach will help you stand on what you've done with unmaking those contracts, and then any attacks that form against you because you choose to live that way and not use identification or any of those things. Equity will help you discharge that case. Um, but as far as being completely left alone, I mean, if you go outside your property at all, then there's always the chance that you can be made an offer by an officer or a county codes inspector or whatever. So you need a tool set to be able to deal with any attacks that come your way, and equity can help you to totally unmake your presence in the commercial world if that's what you want to do, and then more importantly, help you stand on that if anybody ever challenges you over it.
All right. Thanks for your insight.
Awesome. And if I can just add my flavor to that, just in a general, like just even expanding it to just life in general, not just commercially, although obviously, as we've talked about, almost everything in life is imbued with commercial activity. But just in terms of interactions, we talk about the principle of self-defense in terms of, one aspect of being moral is you can't really be moral if you don't stand up for yourself. So there's just an inherent need to stand up for oneself throughout life. It's just the nature of reality that we're going to be challenged. So you're never really going to be able to abdicate. In fact, one could argue that by trying to delegate self-defense, which I think a lot of people are doing, we actually get ourselves in more trouble. We really have a duty as a sovereign being, if you wish, or as a moral man or woman, to always stand up for ourselves. And part of what we're supposed to teach our children is exactly to do that, even just in regular dealings. So I don't think we can ever fully abdicate that if we intend to be moral. It's part of life's lessons. But as Julian, I think to maybe not make that sound like too discouraging, we can definitely learn to get much better at that, and certainly commercially as well.
Yeah, I
So
think
hopefully that
there's,
helps.
yeah, for sure. And I think there's a big difference between totally coming out of the system and the actual path of least resistance. If your goal is just to be left the heck alone, then that doesn't necessarily mean you unmake all the contracts that are going to make it difficult for you to even move around in the world. If you want the path of least resistance and the least hassle, the least stress in your life, then I mean you do get a driver's license, you know. But I mean if you really if it's about standing on the morality of not doing those things, that's not the path of least resistance. I mean it's justifiable and honorable to say I'm done with it and I don't want those things. But you're going to need some serious tools to back you up if that's the path you want to take.
That's also
Awesome.
comes with defending yourself. If you truly believe in something, then that's the road you see, then you go at it, you know. I mean, I just say live and let live. So if I'm allowing you to conduct your life however you want, and I just don't want to be bothered, I think, and I didn't ask for this, I think that you should have a right to say, listen, I didn't want this and I refuse it. So uh, again, I don't want to hold up this
Yeah, but
chat.
there's another side to that coin, Sean. See, the construct is designed to challenge you specifically. This is just my opinion, by the way, so I could be wrong. But the challenge is designed the construct is designed to challenge you specifically so that you can learn to stand up for yourself. I mean, if the world were a paradise where it was just we were all sitting on the beach smoking and drinking mojitos and nothing, nobody ever harmed anyone else, someone might say, well, that's great, but to me that doesn't sound like a learning construct. I mean, what are you going to learn from that? So the whole point of life is to be challenged. And like I said at the beginning, that quote, go back to that quote that I referred to from Jim Rome, which I think it's probably one of my most quoted, requoted statements. All good will be attacked, all value must be defended. It's the nature of reality that when something is good, it can be attacked. It doesn't mean everybody does it. It doesn't even mean most people do it. I do think most people just want to leave people alone. I've interact with people every day. I go out every week. I meet new people all the time. And yeah, 99% of them, they don't want to harm other people. But there is that 1%, and we need to be ready for that 1%. So that's the point.
All right.
And I agree with you, Sean. I mean that you should have the right to do exactly what you just spelled out. Um, but unfortunately, we don't live in a country that honors the right to just be left alone unequivocally. Um, you know, I don't know if you're familiar with Bill Cooper, Milton William Cooper. He had a very in the Patriot world, very famous radio show in the 1990s called The Hour of the Time. He was so far ahead of his time, just a brilliant man. He was even a prophet. I mean, he predicted 9/11, he predicted other events. And he said on his show, because he had begun to be harassed by the authorities, he said, I will not ever allow myself to be taken into custody. I will defend myself to the last drop of blood. This is his words. Um, I stand on the principles of exactly what you just described, Sean, but then he backed it up with, you know, extreme self-defense. And the world was robbed of Bill Cooper just a month or so after 9/11. He was shot and killed on his property when deputies came
Of
to arrest him
course.
over a
Of
trumped
course.
up charge. Now, if he had taken the path of least resistance instead of the path of the most moral high ground in his estimation and in many others, then we would still have that brilliant man today, and the world would
But he
be.
bowed to his masters. Like
He
that's
would not. He chose the path that he chose was not to bow in any way whatsoever, because he knew that he was innocent and that their charges were trumped up, and he
right,
defended himself. Or he
right,
was assassinated. I mean, that was possible too. I mean, the story about that he engaged in a gunfight with the police may not even be true. They may have just, but he did say on his radio show that's what he would do. So we don't know.
Yeah.
I do know that if he had taken the path of least resistance and just for that situation, played it out peacefully and allowed himself to be um, taken into custody, and maybe just used one of those processes that was so popular in the 1990s to potentially discharge the case, we'd still have that beautiful, brilliant man with us today, and the world would be incredibly the richer for his presence. So it's about forgiveness. It's about understanding, when to pick your battles. We are beset by things that we, in a perfect world, should not have to deal with, but we must forgive them, for they know not what they do. If they truly understood it from God's perspective, they'd never be doing any of these things. But until we have that godly perspective permeate across the world, we need to know how to honor the king without allowing ourselves to be harmed. And the best way that I know how to do that is the principles that we teach in equity.
okay.
Excellent. Excellent. Great perspectives. And that was a real deep dive as well. So I appreciate that, kind of looking at things more holistically. So this next question I'm going to read from the chat is bringing us back down, way back down to the details. I'll try to paraphrase it because they wrote it kind of long, but Steve was basically asking, he said he was on the first seminar, so this is in reference to honor with equity. He's talking about using a bill of exchange on a credit card and what happens to the credit card and does the account stay open. I think we already spoke of that on the first, that was answered in the first workshop, but if you want to kind of briefly touch on that, Julian.
Just about what happens with the credit card.
Yeah, and that's in the chat from Steve Connolly if you want to read his exact question. But he's trying to figure out what happens mechanically with the discharge, and if
Sure.
that, specifically if the account remains open. I guess that was the gist of his question.
Yeah, so many people come to us, they're ensnared by debt already, and they need a way out. Obviously, there's a lot of things that have been happening with the economy and the intentional destruction of the supply chains, which cause inflation in prices, and that was all done during the fake virus years. So people are in a tough place with debt right now. The equity that we teach, we've discharged more unsecured debts than I can even count at this point. The account will be closed. To answer your question, the account that particular account will be closed, but you'll still be able to open up future accounts even with the same bank. I mean, we've never seen our students be blacklisted for bringing this process. Sometimes other accounts will be closed as well. Like Capital One is very aggressive on that. If your credit score drops, which it can initially when you bring equity, then Capital One will just start closing accounts, left and right. Not every bank does that. But we do often see the credit score initially drop for 2 or 3 months when the student is bringing equity, and then it'll go back up again. And sometimes it'll wind up higher than when they even started. It's, the credit score is a benefit or a privilege that we're receiving from the banks. It's not something that you have direct control over, though there are ways that we have of getting things removed from the credit report if need be. So the account will be closed. If you're with Capital One, then possibly more accounts will be closed. I don't like Capital One, but overall, you'll still be able to open up future credit cards. Your credit score is not necessarily shot. Oftentimes it goes back up, and of course we have ways of cleaning it up if it doesn't. But the best part is you get to discharge your $20,000 credit card or whatever, and help your family out. And nobody's the worse. I mean, you haven't harmed anybody by doing this. You've actually given them something they can use to truly get paid, and everybody's happy.
Awesome. Yeah, I think that last point that you brought up, Julian, is something that just is worth digesting over and over again. Is nobody's getting shafted. It's not like a win-lose scenario. They get paid and we get left alone. So I think that's what makes it so powerful. Once people can kind of wrap their heads around that and why that's absolutely true. So, quite another question that came from social media. I can answer this one, but if you want to add something to it, they're asking if we're going to, in the class, you teach how to create a business trust. You pretty much already answered that through mentioning that, pretty much all these trusts, there are certain trusts that won't do commerce directly, but certainly many can. So I don't know if you want to discuss that at all, Julian.
Yeah, absolutely. We utilize business trusts. It's critical to the trust system if you're gonna, I mean, whether or not you even own a business. I mean, like I mentioned, everybody's doing business already anyway, just by operating in commerce. Um, for some more heavily regulated industries, people own their own businesses and may need more unique entities setups. But we'll pretty much always utilize business trusts. But yeah, like David said, there's some trust in the equity trust system have more specific purposes and don't do business, and some do.
Excellent. And then somebody asked more of a logistical question about opportunities for payment plans and perhaps alternative ways to pay for the course if someone wants to enroll, if you want to speak to that.
Yeah, we have a three payment plan. If you go to the website, standingontherock.com, and you go to the equity trust system course and you scroll down, you see the payment options, you'll see that there's a one-time payment and then there's a three payment option. There's also the ability to pay with crypto if you'd like to do that. And we can, even if you want to pay with gold and silver, we can work out a way to do that as well.
Excellent. Excellent. Okay, I'm not seeing any other questions. Let me double check social media to make sure I didn't miss anything there. Looks like we're all caught up here. So let's do a last call for questions. So if you have a question that you would absolutely love to ask, now's your opportunity. Go ahead and raise your Zoom hand, or you can also post it somewhere in the chat. Um, and if nobody wants to take us up on that, we'll basically wrap things up here. And I want to just, while people are thinking about that, I just want to again reiterate my thank you to each and every one of you for showing up today. Those of you who are in the Zoom meeting, people who watch us or are watching us on social media right now, 35 people. Thank you to you guys and gals over there on the social media side. We will be uploading the replay of this workshop just like we did with the previous one. So it's going to be up there pretty much in perpetuity, so you guys can go back and rewatch it. We want to make sure that that's available to you. Someone just asked if they can have an invoice to put the cost of the course into their company I guess as an educational expense.
Sure. Yeah, we can do that.
Okay, cool. Cool. So if you just get with Julian if you do decide to enroll to make sure that you get the proper documents. So last call. If not, again, thank you everyone, and thank you, Julian and Margaret, for your great work and for continuing to be on the cutting edge of education, be advanced. And to everyone who's participated, Happy New Year to everyone. I have a very good feeling about this year. We've got a lot of stuff going on. Of course, it's very interesting times to live in, so we'll keep an eye on things. But I appreciate each and every one of you, and I look forward to seeing each and every one of you, either in the course, which I continue to take if you decide to enroll, either course, or just in any of our other events in general. So thank you, everyone, and have an excellent rest of your day.
Thank you so much, everybody. Thank you, Dave.